Hello and welcome to a new video in our series on EU competition law. My name is Hirsbrunner and I am a Swiss and German lawyer at Steptoe and Johnson. One of my areas of specialization is EU competition law, and I'm speaking to you today from Brussels, the EU capital, which, like many other cities, is now slowly coming out of confinement. What I propose to do today is to share a few thoughts about the Lufthansa bailout and some related new developments in EU state aid law. Now you may ask, what is state aid and what is EU state aid law? State aid is part of the European Commission's competition law arsenal. It governs basically control of those selective benefits that the EU member state would grant to a certain company or a category of company through subsidies or loans or guarantees, reduction of taxes, or any other kind of financial support. In the years and the months before the outbreak of the pandemic, the European Commission followed a very tough line in the state aid field. This was illustrated by many high-profile cases over the years involving state aid granted by EU member states to large and powerful companies such as Apple, McDonald's, Starbucks, and others. But when the pandemic struck, it soon became apparent that this tough approach no longer worked. And in fact, the Commission had to give to the member states the freedom to loosen the purse strings, because without that, without this additional freedom, then the economy would most probably have collapsed. So the Commission gave the member states more freedom, but it did so not by changing the rules, but rather by making maximal use of the freedom and the room for interpretation that is already inherent in the existing rules. And it has to be said that the Commission did this so convincingly that many seem to lose sight of the legal constraints and the limits that are inherent in EU state aid law. And they started to develop all kinds of ideas for a new style state aid regime, not only during the pandemic, but also beyond, after the pandemic, what one would do during the recovery that would necessarily have to follow. In this regard, the last 2 weeks were not very different from the weeks before, with Macron and Merkel daydreaming about giving a push for stronger European champions, and of course, the repeated calls from various quarters for favoring green investment. But then came the Lufthansa bailout by the German state, and with it a reality check that was maybe overdue. On 27 May, the Lufthansa supervisory board made a surprising announcement. They took the rather drastic step of announcing that they were unable to recommend the acceptance of a rescue package that had been prepared by the German state. And the board explained that this rescue package for Lufthansa contained additional conditions, consisting with an obligation to divest landing and takeoff slots at 2 German airports, the airports in Munich and Frankfurt. This surprise announcement by the supervisory board was then followed by 3 days of hectic negotiations and much political drama, until finally the same board was able to now announce on the 30th May that the package, although it still contained this obligation to divest slots, was now acceptable. At the moment when this video is taken, the European Commission is still looking at this package, and it still has to formally confirm that it fulfills the conditions for an authorization, but everyone is confident that this authorization will be coming without delay. So, in a few words, what is the background to this highly publicized development? You may recall that I mentioned in my introduction that the European Commission had made a big effort to give the member states more flexibility in the way how they can grant state aid. And that this was really necessary to give the member states the legal certainty that what they were doing does not fall foul of the state aid rules. Now, how was this done? The European Commission created a temporary state aid framework for those COVID-19 support measures. This framework was adopted on the 19th of March. It initially only concerned certain categories of state aid, mainly loans, but afterwards it was amended and expanded in 2 steps, in 2 amendments. Now, what interests us here is the 2nd amendment, which took effect on the 8th of May this year. With this amendment, the Commission took the very significant step of allowing member states to finance the recapitalization of companies in difficulties. This basically means that member states become shareholders of those companies. This may either happen through an acquisition of equity, that means of shares, or it can also happen through the acquisition of so-called hybrid capital instruments. These are basically profit participation rights, silent participations, and convertible bonds. Now, the Commission is rightly concerned about the competitive effects that such recapitalization measures can produce. Indeed, there are good reasons to argue that a company which benefits from a recapitalization and does not have to go apply for a loan from the state, so that just gets the money directly into its capital. There are good reasons to argue that this company has an advantage over a competitor which has to have recourse to these other means, so to a loan or another kind of state support, or maybe even has to go and seek the capital on the market. This is the reason why these recapitalization measures are subject to stringent conditions. In particular, before a recapitalization can be authorized, the member state concerned has to demonstrate that the company in difficulties has no other sources of financing on the market or by the state, or that these other sources are available, but they are not sufficient to cover the needs of the company concerned. Moreover, the amount of the recapitalization must not exceed of what is really needed, and certainly it should not go beyond the capital structure that existed before the pandemic broke out. So the company should not be in a better position than it was before the pandemic broke out. And finally, and importantly, a recapitalization must be in the public interest. So the EU member state must demonstrate that there is a public interest to support this specific company over others. Now, in the case of Lufthansa, one can think of various reasons why a bailout is in the public interest. You would certainly all agree that in case of market exit of Lufthansa, this would disrupt an important service. A lot of plane connections would no longer be serviced between Germany and other EU member states, but also between other EU member states. Some might even say that Lufthansa is systemically important. You saw that there was quite a lot of discussion and debate in the press, in the media, and much of this debate was certainly triggered and revolved around another aspect of the temporary state aid framework, namely the fact that this framework foresees that in a case of a recapitalization under certain conditions, the Commission may make its authorization conditional on certain commitments. In this case, the commitment consisted in an obligation to divest slots at 2 German airports. I have mentioned that earlier, you may recall. Now, I would like to guide you to the text that here is on the screen, and there you see the conditions under which such a commitment can be imposed. First of all, the amount of the recapitalization must exceed certain threshold. It must be over 250 million euro. And second, the recipient of the aid, so the company that is recapitalized, must enjoy significant market power on at least one market. So one can imagine that in this case, the European Commission was of the opinion that for certain air transport routes between Munich and Frankfurt and other airports, Lufthansa had this amount of significant market power, and therefore it was necessary to divest slots. It was necessary to divest slots, excuse me, pardon me. Now, the interesting thing about this, and also something that I might find particularly interesting, is that one can imagine various subplots to this. What first springs to mind is certainly the pressure exercised by competitors such as Ryanair, which will without any doubt launch court actions if the Commission is too lenient and does not insist on this condition that commitments must be offered. But one can also think of other subplots, such as the following. The Commission has more or less said to the member states that it is possible, even in recapitalization cases, to be more lenient, but this would then presuppose that the member states agree to give the power to the Commission to decide on recapitalizations, and also that the Commission then receives the funds needed to undertake these recapitalization measures. What I'm referring to is this idea that is currently being debated in Brussels of creating a fund for strategic investments in companies, Invest EU. So the Commission is saying, I can be more lenient, but then please give me the power and the funds, and I will support your airlines and your national or European champions, whatever. But what it then means is that the Commission will be in control, and it is the Commission that will decide what is in the public interest and who will receive how much money. And you can well imagine that there are certain member states which still struggle with this idea and are very reluctant to give this additional power the Commission and rather have the freedom to decide themselves what they consider is in the best public interest and which companies they want to support. What are the conclusions that we can draw from this? I think first very important point is to underline that EU state aid law still applies even during the pandemic. When I spoke to a colleague recently, he said to me that he thinks the EU state aid rules have been set aside, and you can understand why he would say that if you see all these member states pouring enormous amounts of money into the economy, and there is no sign that the European Commission would stop that. But I think this impression is not correct. And the example of the Lufthansa bailout and the struggle between Germany and European Commission over the case until finally both reached a compromise and one could go into a direction where the transaction could be approved, shows that. And I think this confirms that knowledge of state aid law still is important, and it may even be more important now as the amount of public money in the economy increases. As state aid becomes more important for the economy, also knowledge of state aid law that governs the granting of aid is very important. Second, I think it's also important to bear in mind that the framework conditions are not set in stone. They are subject to changes. And in fact, they are continuously evolving. As concerns the temporary state aid framework that I've just mentioned, it has already been amended twice, and most probably more changes are coming. Under these circumstances, companies are well advised to look out for new developments and to adapt their commercial strategy if necessary. Third point, if you are among the lucky ones receiving state aid, make sure to check that it is compatible. This is very important, and the rules are clear in this regard. You cannot simply rely on the assurances given to you by the authority that grants the aid. You have to carry out your own assessment. And when you have a lot of state aid on your balance sheet, then sooner or later you will have to give account that this is legal at the latest when you prepare your annual account for approval by the beginning of the next calendar year. Finally, if you are a competitor of a company that benefits from state support, remember that state aid rules are there to protect competition. If you feel that this company has been given an unfair advantage, evaluate your options and make your voice heard. State aid complaints are not only reserved to companies such as Ryanair. Everyone who has good grounds to object to state aid granted to a competitor can introduce complaint with the Commission, or if necessary, can introduce a court action before the General Court of the European Union. Now, I hope you enjoyed this presentation about EU state aid law and you found it informative. For me, it was fun to make this video, and I would be happy to have your feedback about the topics covered. And finally, if you are interested in similar updates on EU competition law, please do not hesitate to view the videos of my colleagues that are already on our website. There are 2 videos already, one about routes to market in the new normal, and the second one on market definition. As I said, you will find those on the Steptoe & Johnson website. Many thanks for your attention.